Welcome back, everyone. Thank you so much for staying on and for being here. Are you worried if you are a CISO or you're thinking about personal liability in the context of an IR, in the context of a data breach? This is the panel that you must listen to. And this is probably the hottest issue right now because the government has been so active in this space and it's been kind of controversial. So let's get right to it. We've got a great panel of practitioners. Let's start out with Joe Santiesteban. We are thrilled about having Joe here, a partner in the Cyber Privacy and Innovation Group at the IR powerhouse of Orrick. So what makes Joe's practice such a powerful one is that he's not just a privacy and an IR ace, he's also a litigation ace, which is how a lot of these IR folks got started, handling litigations for a slew of major data security incidents, including LabMD, Hilton, SuperValue, Target, Landry's, Arby's, Genesco. The list goes on and on. He doesn't shy away from fights with regulators. For example, writing recently in an article he co-authored about FTC settlements, the Federal Trade Commission, quote, the FTC's self-described, quote, new and improved data security consent orders are certainly new in some respects, but they are not, unfortunately, improved. Companies facing potential FTC enforcement should raise the continuing deficiency in these orders with the agency if the matter results in settlement negotiations. And if the matter proceeds to litigation, they should also raise them with the adjudicator. In other words, when the alphabet soup of agencies come calling after a data security incident and you want to fight back, Joe is your guy. And his theme song, you ask, what else but Eye of the Tiger by Survivor. And next up is Maneesha Mithal, which I think is the perfect one to follow Joe Santiesteban. The FTC has emerged as a top federal regulator in the area of cyber and has managed to do that on a shoestring budget for many reasons, but chief among them is our next speaker, Maneesha Mithal, a partner at the groundbreaking high-tech law firm of Wilson Sonsini. During her FTC tenure, Maneesha supervised over 150 FTC investigations, many of which resulted in consent orders, including against companies such as Google, Facebook, Twitter, LifeLock, Equifax, HTC. And she's not only just a privacy advocate, she's a woman's advocate. I once read an article in Marie Claire where Maneesha talked about FTC efforts to fighting revenge porn, stalkerware, and a lot more. She's certainly someone who really fought for people when she was at the FTC and worked hard, I think, to earn a reputation as a tough but fair regulator and is universally respected from both sides of the table. Now she's joined the private sector at a firm that seems to me to be the perfect fit for her. She wrote the FTC book on cyber from the inside, so who better to keep law enforcement in check and fight against regulatory overreach during the aftermath of a data security incident. A theme song for Maneesha. It's tough to find the right fit, but my choice would be Try Everything from Shakira, because the song is a journey of fearless inspiration, which is precisely how Maneesha practices law. So welcome, Maneesha. Happy to have you here.
Great to be here. Thanks.
And next up is our good friend, Chief Justice Ed McNicholas, who will be here as a moderator and who's a mainstay for this conference. What you will see in Ed's bio is that he is he's not really a Chief Justice. He is the data privacy and cybersecurity co-leader at Ropes and Gray. And also that you need a terabyte of space to archive all of his accolades and experience, especially the extraordinary number of notorious litigation matters where he has played a part in the hundreds of breaches that he's quarterbacked in response. He's the very model of a modern IR lawyer, authoring a slew of scholarly works on cyber, serving as a law professor at GW, teaching a course on cyber and data breaches, and providing groundbreaking insight on big data and data analytics, which is critical for understanding how to guard against cyber attacks, especially ransomware attacks. What you might miss is that Ed is a multifaceted individual. On the one hand, he is the lead editor of the PLI treatise, Cybersecurity, A Practical Guide to the Law of Cyber Risk. But on the other hand, he also sat on the board of directors of the National Homeless Law Center in DC for 16 years, dedicating a big part of his professional life to ending and preventing homelessness. Ed is the IR equivalent of the revered Supreme Court Justice Oliver Wendell Holmes and the feared Saul Goodman of Better Call Saul. And Ed's theme song, what else but The Room Where It Happens from the Hamilton musical, because that's where Ed has made his home. So welcome, Ed.
Pleasure to be here.
And finally, on a panel about personal liability pitfalls, who better to guide us than one of the more experienced hired cyber guns there is, David Lashway. co-chair of Sidley's global privacy and cybersecurity practice. David has managed incident responses all over the world, including in China, North Korea, and Libya. David is another IR lawyer that is far more than the traditional breach coach. He'll also lead the data breach litigation, the remediation, together with any regulatory and criminal matters that arise. And if a company blames its vendors for a particular breach, he represents them too. He even served as lead counsel to the cyber investigation firm working the hack of the 2016 US presidential election. You won't hear him talk about specific matters because most of the time he's been hired by those firms to handle those specific matters. He's the Jason Bourne of incident response, with special skills, fierce loyalty, fluent in multiple languages, and all the while playing and winning a very high stakes game of his own brand of incident response arbitrage. Given David's global practice, sometimes he finds himself in the most friendly jurisdictions, other times not so much. So his theme song has got to be Living on a Prayer from Bon Jovi. Welcome this panel. Can't wait to hear what you guys talk about. We have a really incredible group of seasoned veterans here. So take it away, Ed. Justice McNicholas, you have the floor.
Fantastic. Well, this is a very easy job to get these three folks talking about interesting issues. This is going to be a fantastic discussion, particularly because the folks here have been through so many of the fights involving large-scale data breaches. And we've seen breaches handled well, and we've seen other outcomes as well. So let's start on a positive note here. CISOs, we all know they're a vital piece of the pie here, but investigations are supposed to be at the direction of counsel. How do you marry those two ideas together? How should the CISO be working with outside counsel? Maybe we'll have Maneesha start.
Yeah. Sure. So I think this question starts not really at the incident; it starts before the incident, right? So you've developed your incident response plan. I think one of the things that we're advising companies is that with the new 8K, the SEC rules requiring disclosure of breaches within 4 days of determining that the breach is material, I think we see oftentimes a lot of loose language before a determination has been made of materiality. And so I think one of the things that we're advising our clients is to make sure you're training people and making sure they're not kind of having loose language about materiality of a breach, making sure that legal is involved at the outset. Now, the response we often get is like, and this is in one of the amicus briefs in the SolarWinds case is, I'm not going to consult my lawyer every time I send an email, right? But I think, and I don't think that's what we're suggesting. I think we're suggesting that even before the event happens, to have the training on privilege, to have the kind of discussion on email hygiene and kind of how to communicate through Slack channels or emails, et cetera. So I think lawyers are going to have to play an essential role in the process. And I think the incident response plan needs to reflect that, and that lawyers should be involved in discussions around when an incident is material.
And I would just, I think, layer into that basically that I think just echoing Maneesha's point about the importance of doing this early, but that relationship between legal and security is critical, and it needs to be both enabling each other, right? So they are both stewards of risk, security risk, legal risk, and they're really only effective when they're working together in that instance. A security incident creates tons of different kinds of legal risk that really do necessitate creating a space for free and frank conversation, right? This is the whole purpose of the privilege. It is not to have, a lawyer in the room to be some kind of magic privileged person. It is that security incidents create a variety of immediate and longer term legal and litigation risk for the business. And you need an opportunity to create, space for free and frank conversation. For that to really be effective, though, to Maneesha's point, it has to start earlier on. Like that relationship there has to be like an existing relationship, the two sides working together. And then you have to have a process. There's a part of it that's like a relationship, and then there's a part of it that's also process, right? Like that has to be developed and executed and practiced ahead of time.
Now, David, a lot of the cases that you and I work on, we parachute in. Maybe not to North Korea. Don't recommend parachuting in North Korea. But
Me either.
It would be great to have that relationship. You don't have it. how do you establish that rapport with the CISO that you just met on their worst day?
Yeah, and I think, it's a good point. And as Maneesha indicated, there's the relationship issues associated with pre-event, at event, and post-event, that construct, left a boom, right a boom, that we've had for 20 years in this space. And I think one of the things that we've collectively as a group of, counsel have been handling among us thousands of these matters over the year, thousands and thousands of them. Some simple principles sort of come out when we observe the key takeaways over the years. On the governance points, the SEC took a shot at it. Nicole did a good job earlier on one of the earlier panels, as we talked about in our pre-call, sort of teeing up certain perspectives around how the SEC took a look at that, what the FTC has said. Aspen has issued a guidance for CISOs and how they should relate to their lawyers. There's been a lot of commentary in this space. And before we get to the, the criminal issues that I know is the core of the panel, I think you're setting this up right. Look, I think the key takeaway from our perspective, and I think a lot of us have seen over the years, is that it's a binary where the company recognizes the CISO as a senior leader in the organization and core to the success of the business. Where that exists, good outcomes. Pre-event, at event, post-event. Where that does not exist, possibility of bad outcomes. And that's because CISOs, like other senior company executives, whether or not the FFIEC, for example, in 2012 in their guidance recognized that and said, break the CISO off from the CTO or CIO because of the potential inherent conflicts in budgeting and other issues. Other sectoral agencies, as we now like to call them under the National Cybersecurity Strategy, have not done that. But where they haven't, even in those circumstances where you're a CISO in a given industry that requirement doesn't exist and regulators aren't expecting that, CISOs still need counsel. Internal counsel, external counsel where necessary. And with the varied and increasingly complex, non-homogenized global legal regimes that all of us on this panel confront every day in our practices, we're handling pre, at, post, as Maneesha said, and Joe agreed. With that conflicting nature of the rules, it only further, I think, stresses the point that CISOs need that counsel. And we've got to be trusted partners, both inside counsel, the people really on the front lines with the client, where they're dealing with the client every single day, and those of us, like you pointed out, Ed, that parachute in either pre, at, or post, depending on a given fact pattern should it arise. But being an internal counsel to a CISO is challenging. And I think all of us on this panel no doubt would agree that where those relationships are enriched and developed, good outcomes. Where they don't exist, bad outcomes on the rising.
So that, this topic would not have been on the agenda 10 years ago. No, people were doing IR, but no one was really concerned about personal liability for CISOs. And then we had two big cases, Uber and SolarWinds. Now, I happen to think they're quite different in terms of the lessons from them. But who would like to sing the ballad of Joe Sullivan? Would that be you, David? Could you hum a few bars of that?
I'm sure all of us on this call would like to. I was delighted to see that Joe just got a new job, as I think many people in the audience and certainly on this panel are fully aware. And I'm happy to sing the ballad of SolarWinds as well, as you know, Ed. We'll be more circumspect around some of these issues because some of us are involved. But I guess what I would say is that before we get into some of the facts and the various agency posture issues and things like that, look, I think there's a lot of confusion in the literature around what these cases truly were about. And I think there's a lot of confusion about what the government's intent with bringing the cases was. And we've heard directly from the government and the people involved on many of these panels in the past, who saw wrongdoing from their perspective and investigated it. I think there's a couple of key takeaways, whether it's in Joe's case or it's in the SolarWinds case. In effect, the government's position seems to be across the relevant agencies where we can talk about each of the individual laws at issue. But silly CISO, not criminal. right? CISO makes general mistakes. We have silly CISO, not a criminal act. No liability there on the criminal side. Don't expect handcuffs. If we have lying CISO, in certain settings, lying CISO could potentially be criminal. And I think what a lot of the commentary is conflates the two. It makes silly CISO, where mistakes were made or maybe oversights or other things, into lying CISO. And I think lawyers on this panel and otherwise that are really involved in these cases and carefully and critically counseling clients around it, including CISOs and boards and other executives and DO coverage, et cetera, are being very careful about distinguishing between the two. And who don't you lie to? Well, the cases make it clear. You don't lie to the SEC, you don't lie in your certificates. Misrepresentation claims in SolarWinds, in the government's view. Whether we agree with that, that's a discussion for a different day. But don't lie to the SEC. Don't lie to the FTC. Don't lie in government contracts. That could give rise to FCA-related liability. Don't make misrepresentations associated with potential misprison, Joe's case, right? So lying CISO, bad. Silly CISO, generally okay, but seek counsel.
Now, I'm not sure I buy that because I think the world is a bit more complicated there.
It is.
I think the case is, we're probably on the same page here.
We are.
The actual facts of these cases are much harder. I mean, a jury found
100%.
beyond a reasonable doubt obstruction and the frequently charged misprison in the Uber case. And that was from evidence presented to a jury that there were documents that were altered and withheld from an FTC investigation in a very kind of intentional wrongdoing sort of way, as the jury found. The allegations against in SolarWinds never proved and still very hotly debated. Maneesha, when a CISO comes to you and says, should I be worried? Should I just not say anything? Just call you before I send every email? I mean, boy, the bill on that would be rough. But what do you tell people? Do you say, don't worry about the FTC, they're not so mean?
Yeah, it's interesting because I want to just kind of echo your point about these two fact patterns being very different. So kind of the Uber, the allegations, at least the kind of paying the hacker to cover up the breach, the kind of not lying to the FTC, those are very serious allegations. And had a client come to me after Uber, I would have said, okay, this is like a one-off. This is like a kind of a sui generis situation. But then we have SolarWinds, and you have allegations about the CISO. There's no allegation that he kind of drafted the statements himself, but that the public statements didn't match the candid internal discussions that were going on. Okay, all of a sudden, I think there's more reason for CISO clients to be concerned. So I think that's kind of the first point I wanted to make. The second point I wanted to make in response to your question is just to layer an additional piece on top of this, which is the Drizzly case that the FTC brought, where they actually named the CEO. And I actually think, so basically the facts there were that the FTC alleged that the CEO didn't pay enough attention to security, hired HR people, hired marketers, didn't hire a security professional, and didn't resource security adequately. And that was the basis for naming the CEO. And I think that kind of brings me to the third point, which is like, what is the regulator's incentive here? What are the regulators trying to do? And as a former regulator, I can say that I think the incentive here is, okay, well, we've tried money. We've tried kind of these 20-year consent orders. We've tried all these other things. And what can we really do to deter bad conduct from our perspective, or unreasonable security practices? And hey, maybe here's a way that companies will take notice if we name CEOs, if we name CISOs. Now, I think the FTC has been a little bit more circumspect about naming CISOs. And I think we see obviously in SolarWinds, the CISO being named. And I think, again, when I was at the FTC, I was persuaded by the argument that you don't want to disincentivize people, good people, from taking these jobs by imposing individual liability on them. And so I think that, a lot of these things are in the mix. And so I don't want to overstate the potential for liability here. I think, SolarWinds may be kind of a poster child for the SEC. But of course, you can't underestimate the concerns. And of course, that's what clients are coming to us with.
Well, and that's the fear here is that it will have that chilling effect. And particularly in this day and age that you'll have CISOs who just take the most conservative posture, and you wind up, a lot of the 8Ks that have come out so far under the new regime have said, something happened, we're looking at it, we don't think it's material, and the little thing in the bottom is, but no one wanted to be the guy who said, don't put out the 8K. So we put out this 8K, got everyone spun up over something we don't think is actually that big of a deal. And if that happens, it's going to be like the early days with California, where you're just going to be flooded with all these 8Ks that are meaningless. And then you say, well, what are the real ones? I mean, Joe, have you seen this is this a real fear? Are people actually that concerned about it, that we're going to mess up the whole 8K system over it?
Yeah, I think CISOs are very, very concerned right now and very scared. And we're talking to them daily about these issues. And I think a lot of it is really unfortunate. And it has really been, like, anybody who's been working in this space would understand that if you're looking to target individual liability at the folks who are not improving or the folks that are not improving security outcomes, it would not be the CISO and the security org. Like, attaching individual liability to the security org whose mission, goal, and is generally consistently trying to improve security and better respond to incidents, the friction that they get is generally not within that org. It is within the business, and because businesses are complicated and have other priorities, right? So I do think it's been particularly unfortunate. The advice, kind of along the lines that Maneesha was talking about, the advice that I really focus on is, I don't think you can over-rotate. We can't be running our security programs and our businesses with the SEC dictates as priority one. It is just an ineffective way to run a security program. Two, where we see the biggest, along the lines of what David was saying, and kind of the, silly CISO, lying CISO, I do think a part of this is two things. Making sure that you're getting the right people in the room for every incident. A lot of the mess ups that we've seen, the SEC has been banging the drum around disclosure controls and procedures. The biggest mess ups that we see are when information is not getting flowed to the right people. And so you want to have a good process to make sure that the right kinds of incidents are being escalated to the right group for an appropriate assessment, and then making sure that the right information is making it to the group that's responsible for disclosures. So there's a part of this that I think is also, that generally is good security practice too, generally. But that's a big part of this that I think I focus on though.
Yeah, one thing there, I think that you're making a really important point, Joe, and I'll go back to what Maneesha said. Look, the lines that I was drawing with respect to the lying CISO and silly CISO, the point is that we don't have a responsible corporate officer doctrine in cyber or in privacy. We don't have a federal statute like the Clean Water Act that has criminal provisions in it. And if you don't meet the standard, depending upon your intent and what the government can allege and prove, they can charge you with a crime, or they can charge you civilly. We don't have that here. Clean Air Act, same thing, right? Other regulatory regimes in the United States, where there are equal or worse economic externalities to a breach, some of those programs federally have criminal provisions or civil provisions, which are largely distinguished in the statute and the case law based upon intent and gross negligence, et cetera. We just don't have that yet in cyber, and we certainly don't have it in privacy. Will we see that emerge? I think that's part of Ed's question. That's a trend line from 10 years ago, back when some of the bigger cases occurred. Ed, we were in meetings talking about the fact with a U.S. attorney at the time who was charging some of the bad guys. Do you think we're ever going to see handcuffs and these types of claims going after a CISO? Right? Are we going to have RCO doctrine? No, could never envision happening, said the U.S. attorney from Pittsburgh at the time. And today we're talking about it on a panel in front of 1,000 people. because it is now becoming ripe. It's in the lexicon, similar to what we're seeing for individuals to be held liable under the DOJ policy with the DAG in her memo to hold individual executives accountable. We don't have that yet under our cyber laws. If you don't meet a standard and you're certified to meeting the standard, that is giving rise under in criminal context, indirectly now. You lied to the SEC, right? Potentially. You misprisoned. That's a crime, right? So the things we're seeing manifest today in the two cases, including in Drizzly, relate to indirect, not direct cyber or privacy controls. We have not developed the law yet in the US that says if you breach the standard, the technical security standard, that constitutes a crime if you did it willfully or knowingly. But that's what Ed is asking. Are we heading there? Some countries, when we look outside the US, as everybody on this panel is fully aware, they have moved much closer in that direction to bring RCO type doctrines into play. Think of India. And so as we are working through the evolution of these theories of liability to the individual, currently, again, silly CISO, you breach the standard, likely not going to be something that results in criminal exposure to a CISO client. And you got to look into that and deconflate these issues. But silly CISO, again, not a violation. But if you lie about it, you got an internal control issue where you said our controls were here, but you actually lied. Welcome to the SEC. Well, and if you did that in a contract situation with the government on a bring down, welcome to key TAM and the FCA provisions. And so that's what I think we got to really carve carefully as lawyers when we're counseling CISOs and executives today, including do I give the guy DNO coverage, et cetera, around deconflating these issues. As Maneesha said, there's not a cute response here, but let's be aware that we don't have RCO doctrine embodied in federal law today for CISOs.
And excellent points. And one of the things that I think about here is that sense of in SolarWinds, the gravamen of the issue isn't an affirmative misstatement. It's an omission that the information wasn't provided. And our friends at the FTC, under some leadership a while ago, started articulating this doctrine of material omission as a deceptive statement. And Maneesha, what do you think? Is that reckless?
Yeah, I think a couple points here. So, what's interesting? I thought it was interesting that the SolarWinds complaint, in a lot of ways, looks very similar to kind of an FTC deceptive practices complaint. And as you mentioned, the FTC had this doctrine of material omissions, but the material omissions doctrine it's very kind of carefully drawn in a way, and it only the FTC only takes actions for material omissions involving half truths. So you gave like a half truth and you omitted material information from that half truth. And so kind of completely omitting information, that's not really a thing under the FTC Act. And I think the SEC has taken it a little further. And I think to David's point about the kind of Clean Water Act and other kind of certifications and people having liability, I think what strikes me is in the security area, and this is one of the perplexing things about the SEC complaint that talks about kind of lying about complying with NIST. Well, NIST is not really kind of an enforceable thou shall do XYZ standard. It's consider this risk and it's identify and it's govern. And I'm not quite clear on how that could be deceptive. And I think, again, when I was at the FTC, one of the things we said, well, we have to have statutory language that's enforceable. It can't be reasonable this and risk-based that. And so I don't think there is something in the security realm. I don't know that there should be, but there's nothing in the security realm that says thou shalt do XYZ and it's a checklist. And if you say you comply with that checklist and you don't, that's a deceptive practice. So that theory was a little bit perplexing to me.
It's almost as if the SEC folks didn't really understand that this was more of a grading scale. Almost.
You said it, Ed, not me.
Just an observation. In the chat, there's a lot of discussion on whether or not civil liabilities is taken care of by it is put them on the insurance policy. Why are we having panels? Let's put them on the insurance policy. If your CISO gets on the insurance policy, he's just like the directors and officers, or she's just like the directors and officers. Everything's taken care of. Is that right, Joe? Can they sleep well at night if they're on the insurance policy?
Well, I mean, David and Maneesha will have thoughts as well, but what I've been seeing is a much stronger push by CISOs for that coverage, it being offered much more frequently. The reality is that the liability is now getting closer to commensurate with other officers of the company. And so similar coverage is, I think more common, but I don't know, David or Maneesha, you have further thoughts on that?
I can jump in. I think that if I were advising a CISO, I would be kind of review these D&O policies very carefully. I think some of them have pretty broad omissions or exclusions. They don't cover fraud, and some of the SEC allegations sound in fraud. And so how do you handle that? They don't cover unfair deceptive trade practices. And if that's the theory, it might not cover that. So I think our advice is just to kind of read very carefully and negotiate what you can and shop around for these policies to make sure that you'd be covered.
What about what about that pesky lifetime director and officer ban? That's hard to insure against.
Yeah, that's where I was going at, which, to follow up on Maneesha's point, right? Read the documents. And again, just another reason why good internal counsel, good external counsel, partnering with the CISO and the security organization generally, and the executive team around the importance of doing that type of work for the org. Because you're not just protecting the CISO. By protecting the CISO, like any other director level official in a corporation, you're protecting the corporation and the business of the corporation. And so sometimes that's not as clear. And as Maneesha pointed out, a lot of the D&O policies just cover directors. They don't list them by name. Some of them have them listed by name or by actual, seat that they're sitting in the back. But some of them are more generic and they just refer to directors. So as Maneesha rightfully counseled, I would agree with her 100%. Reading the documents, carefully looking through those materials and understanding exactly how that math would rack and stack pre-event, at event, and particularly post-event, as things begin to shake out and investigations may result or enforcement actions. Really, really important. Setting that aside for a moment, D&O coverage. Look, I don't think anyone who's been doing this for as long as the people on this panel believe that insurance is the answer here. There have been folks that came out of government and folks that have, sort of gotten into this space more recently, think that might be the answer over time. When you see things like Lloyd's walking away from nation state related actions back in the fall when they issued their missive, and you see the litigation we had in the Merck and Mondelez cases and other cases associated with coverage, and you're going to have a great panel this afternoon with some of the leaders in this space talking about the complexities that we're now seeing in the marketplace, the growing complexities in the marketplace around insurance. Look, to rely on insurance in the context of, well, I can sleep well at night because I'm going to be insured in either the criminal or civil context. I would not rely on that. I would rely on good, careful, hard work to understand what those risks are, read the documents, and do your homework.
One of the early cases where we had officers under the microscope we haven't talked about yet was Yahoo. In Yahoo, the board of directors commissioned a special cybersecurity review committee to internally look at who knew what when. And at the end of that, the CEO had part of her bonus pulled back. The general counsel retired, and the CISO there had already stepped away to another job. But that sort of internal review always struck me as one of the best ways to protect the company. Do you think we've seen a couple of those panels? They're I think more the exception than the norm. Do you think we're going to see more of those special review committees? And jump ball. Who wants to answer?
I'd say I think the more common variant of that is management wanting to know who knew what when. But I agree. I think for the mega breaches, if you will, I do think that's going to, continue to be more common.
Otherwise, look, that potential for the derivative suit, right?
Right. I mean, the good news for all of us in this practice, and I think for the board member, the directors themselves, and senior members of management of both, medium-sized and big companies that are publicly traded is that we've now got a lot of more clarity. Like you said about the 10-year look back, we now have the SolarWinds decision on the D&O action. We've got the Marriott decision, other decisions, right? And so we've got further clarification that Marchand applies, and the principles around duties of care and duties of loyalty are the same in the cyber context, both pre, at, post breach. The NACD has been very active in this area, providing good guidance to all of us practitioners around what the board and what directors should be asking during those various stages of events. And so a lot of us are counseling with that in mind and keeping in mind what the Delaware judge said in one of those cases that I just mentioned, that, after, to the right of boom, after the breach, D&O actions and claims against companies for negligence or what have you in Delaware are like dandelions in the springtime. He wrote on the first page in the first paragraph of his opinion, coming from plaintiffs' lawyers. And those of us who are defense counsel who vigorously defend those types of cases know that, yes, that's exactly what we've experienced. And so I think the sense that we have is that the law is getting clearer. It's easier to explain what the duty of care and duty of loyalty is and when an investigation might be appropriate, either board directed or management directed following on an incident. So I think there's a lot more clarity today than we had even a few years ago.
We've got a lightning round here because amazingly we only have a few minutes left. This has blown by. So to end on a positive note, what is something that a CISO or general counsel can do to help make the CISO feel happier, more secure, and more part of the team, other than put them on the insurance policy? What can we do to make this process work better?
I can start. I would say be good to your CISOs. Companies be good to your CISOs. Have ways for employees to kind of report, escalate, have clear communication flows, escalation flows, who's doing what, roles and responsibilities. I think that breach response plans should address the potential for whistleblowing and leaks, and kind of, maybe there's tabletop exercises that should be done to address those kinds of things. And just, I think, establishing clear lines of communications during incidents. I think we've seen from both the SEC and the FTC kind of this not suggestion, actually almost requirement that that boards be that CISOs often report to boards or their equivalents, and that there's an expectation that there will be this flow of information upwards to officers and directors. And I think companies having taking responsibility over that and having processes and procedures is going to go a long way.
Fantastic. Joe, David, final good thoughts?
Yeah, I mean, along the same lines and like similar to what we were talking about earlier, I think legal's role in this space, a big part of it should be enabling the CISO to do their job more effectively and to communicate more effectively, more accurately, and more effectively. And so I really do think that starting that relationship early and working to build a framework where legal and security are working together to enable the business to make the best decisions in the those highly stressful moments goes a long way.
Yeah, I would echo those, and I would just add that the framework for that we have found to be useful is, look, from our 20 years of plus doing this, CISOs are great folks, right? They're incredibly empathetic. They're some of the most hardworking people at companies, dedicated to the mission, and they're on the wall every day. They've got a SOC. They're looking at a GUI, and information's coming in from a variety of different sources, whether it's their varied threat intelligence feeds, to system operations, to what's going on their firewalls, to patch suites. And what we like to think about this from exactly that perspective. Put in that GUI legal. Just like the CISO gets threat intelligence on a daily basis and threat intelligence updates, get an internal lawyer with the help of external lawyers where needed, feeding into that GUI, into that CISO, changes in the law, changes in standards, changes in risk and perception, so that CISO can truly risk manage, informed by this evolving legal standard that we're all dealing with. And if you treat it as part of that engineering design, that really talented CISO can absorb it, understand it, and factor it into all the decisions he or she makes across the security risk paradigm. So get in the GUI if you're a lawyer.